Good morning, good afternoon, good evening, wherever you are. Welcome to Just Law Legal Information sections. My name is Emmanuel Patrick. I am an LLB candidate at the University of Lay Adventist of Kigali and also currently the International Students Representative. So I've elected to use my platform to discuss and share legal information regarding several key topics, some of which include contract law, tort liability, international humanitarian law, criminal law, and criminal and civil procedure. Please kindly follow my page on Facebook, Instagram, Twitter, and TikTok to view my contents. So to begin today's discussion, we are going to be talking about introduction to law. When we hear the word law, what comes to our mind? So basically, we are going to be discussing the definition of law. We will talk about the characteristics and the functioning of law. We talk about the characteristics of the rule of law, the sanctions of legal rules, and we will also be discussing the sources of law and the branches of law. So to begin with, what is the definition of law? What is law? When the word law is being used, what comes to your mind? First of all, in accordance with the Black Law Dictionary, it defines law as a body of rules, of actions or conduct prescribed by controlling authority and have a binding legal force, that which must be obeyed and followed by citizens subject to sanctions or legal consequences. Also, we can consider law to be both objective and subjective. When we discuss objective law and subjective law, what are we talking about? When we talk about the objectivity of law, basically what we are discussing are those rules that govern people's conduct in a society. While the subjective sense of law refers to those rights that are bestowed on a person by the objective law. And some of those rights includes the right to property, the right to privacy, and the right to freedom of speech. So we are also going to be discussing, but before going to the characteristics and the functioning of law, we are first of all going to look keenly at the definition of law. Whenever you are asked, or maybe when you are asked to define law, there are a few things that must be in your definition of law. Some of those things include: one, it is a body of rules. It is a set of rules. Two, it guards people's conduct. Three, it must have a binding legal force, and it must also have consequences. So when there is a breach of law, there are consequences. So we also go to the characteristics and the functioning of law. It says the establishment of law is intended to serve several purposes, some of which includes to keep the peace, maintain the status quo, preserve individual rights, protect minorities against majorities, promote social justice, and provide for orderly social change. In fact, you cannot discuss the characteristics and the functions of law without mentioning the legal fundamental principle ubi societas ibi jus. What do we mean by ubi societas ibi jus? Ibi societas ibi jus is a legal principle which is translated to mean where there is society, there is law. This principle revolves around the concept that law and society are indispensable and indivisible. It also states that the maintenance of peace and harmony of a society will happen efficiently only if there is a law for the society. Moving further to discuss the characteristics and the functioning of law, we said the law must be in the interest of the people. The law must treat equally and not discriminate. This means it must be applied equally to every citizen, whether you are a rich person or you are a poor person, or from this ethnic group or that ethnic group, the law applies to everyone equally. The law must fairly balance individuals' rights with community good, control social relations and behavior. It also provides the machinery and procedures for the settlement of disputes. So moving forward, we are going to look at the character of rule of law or legal rules. What are the character of the rule of law? So the rule of law is characterized by the binding or obligatory character, the permanent character, the general character, and the coercive or authoritative character. When we hear binding character of law, what comes to our mind? It basically means that no one can derogate or deviate from the rule of law as soon as it is entered into force. It says that a legal rule is binding, meaning that it requires you to do something or not to do something. Binding also means that it is supposed to be followed by all citizens. A legal rule is binding in time and in space. When we discuss in time and space regarding the binding of a legal rule, basically what we are saying is legal rule is said to be binding in space when it is, for example, applicable to a particular territorial jurisdiction. Also, a legal rule is binding in time when it exists from a certain date to a certain date. Further, the permanent character of law is that the applicability of the rule of law is constant during its existence. A legal rule is permanent. It means that it is applicable or not interrupted between its inception and its end. So from the time the law is being brought into force to the time that law ends, the application of that law cannot be changed. So we're also going to look at the general character of law. The general character of legal rules, the law is enacted or formulated in a general sense. A legal rule is always general. This means that it applies to persons in general, but not to a particular person. However, legal rules may apply to a group of individuals. So the next character of the rule of law is the coercive character or the authoritative character. It's a public power may be used to enforce legal rules. These include civil sanctions, which aimed at protecting the private interests of persons, criminal sanctions protecting the society, and disciplinary sanctions aiming at adjusting the conduct of employees. And now we move over to the classification of law. Law can be classified into several segments. Basically, law can be classified into substantive and procedural law. What is substantive law? Substantive law sets out the rights and the duties governing people as they act in the society and specifies remedy to back up those rights. Duties tend to take the form of a command: do this or do that or do not do that. For example, the Rwandan Labor Code tells employers that they must not discriminate amongst people in hiring and employment on the basis of race, color, religion, and sex. Substantive law also establishes rights and privileges. Example, freedom of speech, the right to self-defense. On the other hand, procedural law establishes the rules by which substantive law is enforced. It does not define the rights or duties, but merely implements them. Rules as to what cases a court can decide, how a judgment of a court is to be enforced, are part of procedural law. And lastly, we are going to be discussing the sanctions of legal rules. There are three main types of sanctions attached to a legal rule. We have the criminal sanctions, we have the civil sanction, and disciplinary sanctions. What is a criminal sanction? A criminal sanction is attached to criminal offenses or offenses committed against the state. For example, murder. When murder is being committed, the killing of another person intentionally, willfully, and premeditated is murder. So it is a crime against not an individual but against the state. So therefore, criminal sanctions is attached. And then we have civil sanction. What is civil sanction? Civil sanction usually deals with damages or reparation. Basically, when an offense is being committed against another person, for example, assault. Assault may be either a criminal offense and a civil offense. So if a person decides to seek damages for an assault, basically it is a civil, they reward them damages or reparation, which is a civil sanction. And disciplinary sanctions as well. Disciplinary sanction is usually applied to members of military who fail to live up to their obligations or the uniform code. So I also like to talk about the sources of law. What are the sources of law? There are several sources of law. There are secondary sources and there are primary sources of law. So today we'll be discussing the Constitution as a source of law. Another source of law is legislation or enacted law. We have precedents. We have general principles of law, doctrine, and customs. And lastly, we will be discussing the branches of law. See, law can be divided into two main branches, private law and public law. Private law deals with the rights and obligations people have in their relations with one another. Private law determines a person's legal rights and obligation in many kinds of activities that involve other people. Example, contract law, property law, and family law. Public law, on the other hand, concerns the rights and obligations people have as members of society and as citizens. In short, public law governs relationship between the citizen and its states. Example of public law may include criminal law, constitutional law, administrative law, amongst others. Thanks for watching my video. Please kindly follow, like, and share my video for more contents like this. And please also let me know if there is anything you would like me to improve during the next video. And you may also write a comment and let me know on which topic you would like me to discuss next. Thank you so much and have a blessed day.